morning. This is Crash Talk. I'm Mike Harber, your host, and backed by popular demand, I was contacted and asked if we could have Monty come back and talk some more. So I'm not an attorney. I'm not going to be giving any legal advice. If you need an attorney, seek that from a practicing attorney in your area. We can give you a referral. Monty is an attorney, so some of the things he's going to say, he's responsible because some of it's pretty shocking. Monty, we're back. We had a great show when we went over the stuff that you shared with us last week, which was shocking. There's been a number of comments about some of that that people were just amazed. You've got so many stories to share, and so you've sent me a number of documents, things that you've dug up in the past. So you tell us some of your favorite stories, some of the things that you've been involved in. If you want to tell us some of your theories, where you're going with your law practice. And you're a practicing attorney in what state? In what state?
California, but I also admitted to practice all the way to the Supreme Court of the United States. But I've done stuff in other states too. So. But
okay.
You got to remember something, Mike. I'm 79, and I can't do it. I got to find some attorneys to take over, especially in areas of class action. But there's a couple of things that consumers really should know, though. And if you don't mind, I'll go through a couple of them.
Yeah, we'd love to hear what your thoughts are.
Okay, first of all, the insurance company's got a way. They convince you that if you're hitting a car accident and it's the other guy's fault, and they offer to pay, let them pay. That way you don't file a claim against your own insurance company. Have you heard that one?
You're preaching to the choir. I've been trying to enforce this over and over and over because that's probably one of the most important pieces of advice you can give. Yeah. Because the at-fault party's insurance company, they have no duty to you.
Yeah, right. It's worse than that. Here's the reason. If your insurance company pays the car, who's actually paid for the payment for the car? You have, through your insurance premiums. Let's assume that you paid insurance premiums of $2,000 a year for 10 years. Never been in an accident. Okay, that's $20,000 with the interest you've earned, that's $30,000. Now your insurance company pays it. You paid for it, not the other guy.
Exactly.
So you paid for the benefits. Take the benefits. Now, why is that important? Now you sue the third party who hit you because they're liable for the full amount of the damages. And you recover those. And the other side gets no credit for what your insurance company paid. And the Supreme Court of California says that that's okay, even if it makes a double recovery for you. You've paid for it. If you put it in the bank or you purchase a contract to pay for it, you're the one that's paying for it. The person who's liable to hit you, the Supreme Court says, and I'll read this, it's called the collateral source rule. It says the collateral source rule as applied here embodies the concept that a person who has invested years of insurance premiums to assure that his expenses should be, he should receive the benefit of his threat. The tortfeasor should not gain any benefit from the victim's prudence. But you resisted, they don't get credit for it. You get credit for it, you get your car paid for by your insurance company, and you also recover it from him as well. Now, that's California Supreme Court. That's why the insurance companies try to convince you to go to the other guy's thing, because you can get it, and the other insurance company has to pay. Did I make that clear or not?
Well, the collateral source rule is a little bit confusing to me because it gets into a lot of the medical type recovery and med cost. But when we're talking about property damage, and I 100% agree. You always want to use your own insurance company,
right,
just because they have a duty of good faith and fair dealing. And
right,
you said you've paid for that benefit. You
right.
haven't paid the other side for a benefit. And
Yeah.
unfortunately, they can do whatever they can get away
You're
with.
right. They don't owe any obligation of good faith and fair dealing. Now, your insurance company has an obligation of good faith and fair dealing. And, you know, I started to put together a book, I still got to do this thing. But a couple things that you can consider, that if your insurance company or any insurance company is going to repair your car, you should consider very carefully whether or not that car should even be repaired, especially with the loss of risk involved there. Now, you know how the insurance companies will say, well, I think California, they use basically an 80% rule. We'll pay up to 80%. Why do they do that? Why would you pay $28,000 to repair a car that's worth $40,000 if after it's repaired, it's only worth $16,000? That doesn't make sense. But here's the reason why. That insurance company, by paying the $28,000, had they totaled the car, they got back $8,000 for salvage. They'd had to pay $40,000. They'd have been out of pocket $32,000. This way, they're only out of pocket $28,000. But look at the owner of the car; he lost $24,000. So
Now, that's interesting to look at it from that standpoint, because in our state, the state of Washington, I don't know California, but in the state of Washington, the Supreme Court case was Moeller versus Farmers. And in that case, that Supreme Court case, it was a first party claim. David Moeller was insured with Farmers Insurance. The accident was his fault, and he made a claim against his own insurance company for diminished value. And it went all the way to the Supreme Court. It took 14 years to get a decision on that. Mm-hmm. And what the Supreme Court said is that the vehicle has not been returned to its pre-loss condition. It has ongoing damage because things, as you've already mentioned, I think even in our prior episode, about how crush zones and straightened metal is weaker, and you've got then other areas of paint, and all of those things are not the way it came out of the factory, no matter how good the repair is. So what happened after Moeller, all the insurance companies in this state have put an exclusion in the policy on a claim. If you make your own collision claim or a comprehensive claim, you cannot make an additional claim for the diminution. So they're getting away with what you just said. They'll do a $28,000 repair or a $30,000 repair on a $40,000 vehicle.
They will, because they make a profit, but you lost because you've suffered the loss. And quite frankly, here's the big issue that the courts, attorneys, legal professions, where I'm coming from on this, is insurance by definition is a contract. It's not just any contract, it's a contract to indemnify you for loss. And the word is loss, not repair cost. They indemnify you for a loss that's caused by an occasion. And I think, Mike, I think I sent you a summary. I don't practice law in Washington, but I pulled up the summary here.
Sure.
Washington statute says it's a contract whereby one indemnifies another. You're indemnifying for the loss. Property insurance is an insurance against loss or damages caused by a hazard. Insurance damages, it just repeated over and over, it's loss and damages. But the loss or damage is what you're insuring against caused by the accident. Now, the accident doesn't cause the repair costs. That is a human decision that's made later to try to reduce the amount of the loss. That's got nothing to do with the loss. The loss occurred prior to that. I like this example. This is one of my crazy ones again. But if I had an antique vase that's worth $1,000, and I insured it for $1,000. Somebody stole it, I'd get $1,000 because it's gone. But if it dropped it and cracked it, and I could glue it back together for $5 worth of crazy glue, and the insurance company says, look, we're going to reimburse you $5 where you buy some crazy glue and glue it back together. Now it's only worth $50. They said, well, you got no loss. Guess what? We glued it back together.
Did you happen to read, and there's probably so many things around for you to be looking at, but in Moeller, because I was the expert in that case.
Yeah, right.
I was involved from David Moeller was my client. And so the defense in that case used the example. They said, if you broke a china plate,
right, same thing,
and you glued it back together, you still have a china plate. And it was just like, they used that as the defense. And it was just like, to me, I mean, I'm not very smart, but if my wife, if I broke her china plate and I said, hey, darling, I'm going to glue it back together and it's just as good, I can still eat a steak off of it, but it's got this line through it where the crack was. I mean, really?
Yeah, that goes back to the old parachute. I think I told you about once before. I fixed the parachute, so if it doesn't open, hell, bring it back, we'll fix it.
That's great. That's
okay.
Great. Well,
but here's the point, and here's where I'm going now. Insurance, California says insurance is a contract to indemnify for loss. The first case in American history to decide that case was in 1840. And the 1840 case obviously didn't involve a car, it was a ship. And the insurance company repaired the ship that had been damaged in the storm. And after it was repaired, the owner says, look, it's been repaired, but it has less value because it's the way it's repaired. And the insurance company says, no, our only obligation is repair it. Sounds familiar, right? The Supreme Court of Massachusetts in 1840 says, what is indemnification other than you pay for the loss? And the loss is the loss of value. It has to be covered. That's been the law since 1840. In California, it says the insurance companies shall pay for the loss. Now, here's where I'm coming from on this one. And this is where I really would like to find some attorneys that would wake up and help me out on it. If insurance is a contract to pay for the loss, but the insurance company puts in there, we don't have to pay you for the loss. All we're doing is we're going to have to repair it. We'll repair it. Then that's not an insurance policy. That's not a contract for insurance. They advertise it on television as insurance. They promote it as insurance. They convince you they're selling you an insurance policy. You never see it before you buy it, but they're to deliver to you an insurance policy. But what they give you is a contract to repair the vehicle to try to mitigate against the loss without paying you for the loss. Now, they've used television. That's wire fraud. That's television fraud. But that's deceptive business practices in California. And thus, the remedies for that is federal racketeering, obtaining money by false pretenses, and the law is that everybody who has paid the premium for that is entitled to a refund of the premiums they paid. What we got going now, and I've had to go out of the state of California to find an attorney that would work with me on this. We have one filed right now in Sacramento. Again, I'm available to consult, but the one in Sacramento is against State Farm, one of my favorites. And in that case, we're suing anybody whose car was damaged. They're entitled to the diminished value for the last 4 years, class action. Anybody whose car wasn't damaged, they paid for an insurance policy that wasn't an insurance policy, they're entitled to a refund of all premiums they paid for the last 4 years. Now, am I crazy? Yeah, probably am. But I started this theory back in about 2017 of what is insurance? And I've written some articles. It's all on my computers and everything else. And this theory that if you have falsely advertised that you're entitled to it. Now, there was a case that came down in 2018 that's right on point and supports my theory, called Davison versus Kimberly Clark. Now, Kimberly Clark makes flushable wipes. Okay. But the trouble of it is they didn't dissolve when you flushed them, and it'd stop up your sewage line. And they advertise it as having a characteristic, just like the insurance company says it's got a characteristic. We pay you for the loss. That's it. We're selling insurance. They were selling it as flushable wipes. It goes to the Ninth Circuit Court of Appeal. The Ninth Circuit Court of Appeal that says if one advertises a product that does not have the characteristic of which it's represented to be, the buyer is entitled to restitution, a refund for all premiums paid. Well, I figure that if it'll work for the bathroom, it should work for the garage as well. It may even work on a car. That case has been cited 23 times. Nobody seems to pick up the fact that I believe everybody is entitled to a refund of all the insurance premiums paid. And I got cases of Geico, I got so many of them. AAA does the same thing. If they put it in their policy that they don't pay for the loss, then that's not an insurance policy under any law, including, as I pointed out, I just picked up the Washington and run off and shot it to you. You got to pay for the loss, not the repair cost. So that goes way beyond Mueller, the Mueller case.
Well, but you're making me think, because now if they've put this exclusion in there, I mean, it's a contract. But if they're selling it as insurance and they're putting an exclusion in the contract where they're not paying the loss,
that's
I mean,
fraud.
they seems like these policies. If you read a policy, the insuring agreement is usually one paragraph. And then you'll have 2 pages of exclusions. You know, I mean,
here's the point. Here's the point that it's got to be recognized. They can exclude a certain risk. For instance, your policy says if it's time of war, your car is destroyed in a war, or nuclear, that's a risk. You can exclude the risk, but you cannot exclude the obligation to pay for the loss if the loss was caused by the risk. So you got a car insurance where the risk is a collision or car accident. If that occurs and causes the loss, they cannot exclude the payment of the loss.
wow.
There's a difference between the exclusion of a risk and the exclusion of a loss. And the California Supreme Court, as well as the United States Supreme Court, points out that if the exclusion violates California's policy or any state policy, that exclusion is void. VOID, it's unenforceable. Flat out. I think of the thing of it is, I know, I wish I could find the right people to work with on that, because we're talking about national class action. I got a phone call from an attorney up in your area, come to think of it, out of the blue, wanted to know what I was doing with it. And I was trying to explain it to him. That was going after it. He said, man, that's the largest class action in the United States. I said, but how do you know me? I've never dealt with it. He says, oh, I was the staff attorney at the Ninth Circuit Court of Appeal. And you know who you are. So he left after 9 years. But I would like to go that route, because quite frankly, why would I buy insurance if they're not going to pay me for the loss?
Right.
I pay it in the bank.
Yeah.
I'll pay for my own loss.
Yeah.
I don't need it.
Right. Well, Monty, wow, you're amazing, and you even though you said that you've got a few years on most of us, I think you're certainly not slowing down. I would hope as the word gets out about some of these ideas that you have, that maybe we could find some other attorneys that would be willing to partner up with you and move some of this forward, because this sounds huge.
Well, the thing of it is, the deal about the insurance policies has only been in the Ninth Circuit one time, as the case that I brought. And in that case, the Ninth Circuit reversed it. And they said that if the loss is caused by the accident, it's covered. No matter. And there is, look, Frank Sinatra, you love him, right? Everybody loves Frank Sinatra. He's had that song out that says, love and marriage goes together like a horse and carriage. You can't have one without the other. Guess what? You can't have a loss without diminishment value.
Right.
And you can't have diminishment value without a loss. It's the same thing. You can't exclude the obligation to pay the loss. Does that make sense? I'm sorry.
No, I'm starting to think that the exclusion itself almost seems to be violating the concepts of legal principle.
Well, let me put it this way. I'm going to read. Any portion of an insurance contract which is violative of public policy is not enforceable, period. Ritters versus Mutual Life Insurance Company, 1894. That's 168 United States Supreme Court, 123. California is the same thing. And by golly, I love that old 1800s back when you used to really have to think about it. And that's still a law today. That's never been overturned. California has adopted it. The Supreme Court has. Nobody will enforce it. The departments of insurance won't enforce it. Attorney generals won't enforce it. When it comes to the insurance industry, and I look at the thing with the farmers back east where they settled the case for $215 million for federal racketeering, for involved payments to benefit judges. I don't know what I'm up against. I'm a one-man office. Can
we have another time together and talk about that whole issue? I imagine, because the media never exposed that, which went on for years and years and years, and it almost sounds like something that a movie could be made out of. But we've got to kind of end it for tonight. And Montie, I appreciate how you and I had to work it, even making this happen, because both of us are a little bit technically challenged, but we got there. And so the next time, maybe this will be a little bit easier.
I appreciate it. You know, I'm a technical idiot, but that's the way it goes.
All right. Montie, thank you so much.
Okay. Thanks, Mike.
All right.
Talk to you later.
I can see why people want Montie to come back, talk to us. Just good guy. Thumbs up, thumbs down. You know the routine. Let us know if you like, if you don't like. Just give us some feedback. Send us cards and letters, emails. Go to harberappraisal.com. You can comment there, or you can even go to the CrashTalk.com landing page and you can send comments or suggestions, questions, so we can answer for you. So wear your mask, keep your distance, stay safe. We'll see you same time, same place next week. Good night.